In this second module, dealing with our rights and obligations under contract law, we build on the work in the last module that examined whether or not we have an enforceable contract to think about what's in the contract, what have we actually agreed to, the terms of the contract. As well as that, we get a brief introduction to remedies, or what we can do if someone hasn't kept their part of the bargain. So with that in mind, let's get going. In the last module, we looked at what a contract is, what we have to do to form a contract, and then what might make it unenforceable. We concentrated on some of the topics within the broad spectrum of the true breadth of contract law, but I think we've got a good understanding now to move forward. So if we've got a contract form, our next question becomes, what are the terms of that contract, or what is it that we've actually agreed to, and what happens if one of the parties doesn't keep their end of the bargain? So if we think about how many contracts come into being, admittedly not all of them, but many contracts, there's an interchange between people. One person will say something about what they want from the contract, and another person will reply, say, yeah, I agree to that, or I don't like that. And so we'll have this interchange between expressed desires for the contract. So one of the fundamental questions that contract law tries to answer is which of these statements actually form part of the contract, a term of the contract, and which of these statements are not part of the contract, particularly where these interchanges might have gone over the course of days or weeks, even months or years. What have we actually agreed to? Is it part of the contract, a requirement that we need to fulfill? Or is it just something we've said as part of the negotiation process to try and get the other party to agree? Because if it's a representation, then we don't have to follow through on what we said. However, if it's a term, we do. For this particular subject, we actually break terms down into two categories, a condition and a warranty. I do understand that sometimes the courts talk about a middle category, indeterminate or innominate terms. That can be a little bit confusing for us in business law. It's roughly the same logic works. It's about whether there's a breach of a serious term, a serious issue, or whether it's a breach of a minor term. And so to help us think that through, for the rest of the course, we're only going to talk about conditions and warranties. So a condition is a very important term. We'll come to the definition of that in a minute, but it's a very important term of the contract. And a warranty is a less important term. That's a way of thinking about it, okay? So think about this. There are very important obligations and less important obligations. There's still both obligations, there's still both terms of the contract, but they have different outcomes, different remedies. If you breach a condition, well, you can get damages, but you can also terminate the contract. If you breach a warranty, one of these lesser terms, you can only get damages. You can't actually get out of the contract. That's why the classification system is so important. Perhaps an example might make this a bit easier to understand. Imagine you go in to buy a bicycle and you're discussing with the bicycle salesperson about the kind of bike you want, and you say, hey, I need a bike, and the bicycle salesperson says, well, this model here, it's a great bike, okay? It's a great bike. And you say, I'd like to have some streamers coming out of the handlebars so that it looks nice. And the salesperson says, yeah, we can attach the streamers, no problem. And then you say, yeah, and disc brakes, I really want brakes that work because it's super important. I'm a bit unsteady. I need to be able to stop quickly. And the salesperson says, of course, we'll have disc brakes on the bike. So you buy the bike, you agree, yes, I'll take that bike. And the salesperson agrees, we'll put the streamers on it and the disc brakes. And you pay the money and you get the bike. So there's consideration, there's intent, it's in business, you have agreement. But when the bike's delivered, you find three things. Number one, there are no brakes on the bike. Number two, they didn't attach any streamers at all. And number three, you don't think it's a great bike. So here we have 3 statements being made as part of the contract, and we've got to determine what's in the contract, what is a term, and then also what you can do about it, given that the bike shop hasn't delivered on those terms. Okay, let's deal with the first one. It's a great bike. Great bike. What does that actually mean? At law, that's going to be considered puffery. It's just a statement to induce you to enter the contract. It's not actually a term of the contract. It's a representation. So if someone said, I'm going to sell you a great steak, the best steak in Brisbane, and you get it home and it's edible, but it's not the best steak, it's not a breach of contract. They're just saying that to get you to buy the steak. It's normal advertising puffery. So that statement, it's a great bike, would be a representation. Now, how about the brakes? Well, the brakes, look, it's important that a bike has brakes. In fact, you made it clear in the interchange that you wouldn't have bought this bike without brakes. That term is a condition. The streamers, well, nice to have, right? People buy bikes without streamers all the time. There's no reason from our interchange to think you wouldn't have bought the bike without the streamers. You just like to have them. Attaching streamers is a warranty. So here we have 3 different outcomes in terms of these statements from the bike person. 1, it's a great bike, is a representation. 1, it's going to have disc brakes, is a condition. 1, the streamers, the nice to have, are a warranty. What does that mean? If they had have attached the brakes but not the streamers, you couldn't take the bike back. All you could do is sue for damages. You could get enough money to buy your own streamers and have them attached, but you'd still have to take the bike. However, because they didn't ensure disc brakes were installed, you can take the bike back because they've breached a condition and you can terminate the contract. That's why this classification system is so important, because it affects your options, what you can do if they haven't followed through on their promise. And notice, there's nothing you can do if you don't think it's a great bike, because that's puffery. So let's think about that a little more formally. So once we've got our agreement and our intent and our consideration, we have a simple apparent contract, and imagine that it's enforceable, we haven't done anything wrong. Then we need to understand what obligations have been created by that contract. Those specific rights and obligations we call terms. Now, in everyday language, you might have heard them called clauses of a contract or provisions of a contract, even stipulations of the contract. But it's the same thing. We're going to use the word terms for the rest of this mod. We're also going to concentrate on the 2 key types of terms in a contract. Conditions, the important terms, as opposed to warranties, which are the less important terms. The key difference being that if you breach a condition, you can terminate the contract, whereas if you breach a warranty, you can't. Now, whether a term is a condition or a warranty is determined from the perspective of an outside objective observer. Would an outside objective observer, taking into account the conduct of the parties and what went on and the context, knowing all of that, would they think that this was a very important term, a condition, or would they think it's a term of lesser importance, a warranty? And some of the precedents around this might help us understand. In Associated Newspapers and Banks, a cartoonist was deciding which newspaper to put their cartoon into. So this might be a bit foreign for students these days, but there used to be these old things called newspapers, and in the middle they had a cartoon section. And there's a very famous cartoon called Ginger Meggs. Anyway, the author of this cartoon, the author-illustrator, was deciding which newspaper they were going to place their cartoon into, and the newspaper that they went with, the one they decided to contract with, had said to them, we're going to put your cartoon on the front page of the cartoon section. Now, this was very important to the cartoonist because it meant it got a lot more exposure, more people are going to read it, and would increase the prominence of their cartoon. After they commenced the contract, what of course happens is the newspaper doesn't put it on the front page of the cartoon. They start placing the Ginger Meggs cartoon in the middle of the cartoon section. And the cartoonist is upset. This was one of the important reasons as to why they chose that newspaper and not the other one. And so they sued the newspaper for a breach of contract. Now, the decision before the court, is this a breach of condition or is it a breach of warranty? Because if it's a breach of condition, then the cartoonist can enter another contract with the rival newspaper. It gives more options to the cartoonist as to what they can do, more leverage and bargaining power. And the test that the courts use is whether the term is of fundamental importance to the contract. In other words, would the party have entered this contract without that term? If the answer is no, if the answer is this term was essential to the contract, the parties wouldn't have entered the contract without that term. If you can answer that in the affirmative, then it's a condition. And that's what happened here. There was evidence that said the cartoonists wouldn't have entered the contract if they hadn't have guaranteed that the cartoon was going to be on the front page. And so because of that, they'd breached a condition. This was a condition of the contract, not a warranty. And as a result, the cartoonist had the ability to either confirm the contract and say, I want to go ahead and get damages, or they could terminate the contract, get out of the contract, which would allow them to sign another contract with the rival newspaper and get damages as well. That's the flexibility that you get as a remedy if there's been a breach of condition. Now, terms that are of lesser importance are called warranties. This can be a little bit confusing because most people, when they hear the word warranty, start to think of some extended electrical appliance guarantee that you get from your local retailer like Harvey Norman. That's not what we mean by warranty when we're talking about contract law. A warranty simply means a term of lesser importance. And really, that's where the vernacular or the normal use of the word warranty is this extended warranty, this extended repair option comes from, because you're probably going to buy the fridge anyway. So the additional warranty that came with it is of lesser importance than the appliance that you're actually buying. So really, the normal use of the word warranty is just one example of what a warranty is. We need to think more broadly, and that a warranty means simply a term that is of lesser value. It's a term that isn't essential to the contract. What that means is you would have entered the contract without that term. Or to put it another way, it's a nice to have term of the contract, not a must have term of the contract. Bettini and Guy is our case authority for this, where this principle is put in place. And what happened in that case was we had an opera singer contract with a production company, and as part of the contract, they had to turn up for a certain number of days for rehearsal and then a number of performances. And the opera singer didn't turn up to a couple of the practice sessions. They did make all the performances, etc. And the court held that the performances were the essential part of the contract, right? They turned up to enough practices to make sure that the performances went okay. But when the opera singer didn't turn up to all the rehearsal sessions that they'd said they would, it wasn't a breach of condition. That wasn't essential to the contract. What was essential that they turned up to the performances, not the practices. And so in this case, they said not turning up to all the practices was a breach of warranty. And as a breach of warranty, the injured party could only get damages. They couldn't get out of the contract with the other party. Okay, so what we've essentially done now is said, look, we've got three categories of promises that people make to each other. Representations, which don't have any obligations or liability associated with them, and then terms, which we can split into conditions and warranties. And we've come up with the common law principle about how to tell them apart. Now we're going to go a little bit deeper into how we tell whether statements actually form part of the contract or not. And we'll do that in the next video.